Imagine losing your career, your life savings, and your reputation tonight, not because you broke a single law, but because you fell for a forward psychological trick designed by police academies to make innocent people incriminate themselves. You're driving home. The road is empty. Suddenly, the flashing red and blue lights pierce through your rearview mirror. Your heart rate spikes. The officer approaches your window, shines a blinding flashlight into your eyes, and casually drops the ultimate trap. I smell alcohol on you. Now, listen to me very carefully. The very next sentence that leaves your mouth will dictate whether you sleep in your own bed tonight or on a concrete slab in a holding cell, fighting a legal battle that will bankrupt you. And the response that 99% of drivers give is the absolute fastest way to destroy their own life. In fact, it is such a catastrophic error that by the end of this video, you will be terrified that you ever thought it was the right thing to say. But I'm not just going to expose the trap. I am going to arm you with a highly specific, legally bulletproof script that entirely neutralizes the officer's interrogation, forces them to respect your rights, and legally binds their hands. And I have the constitutional case law to prove it. But this is where most people fail. They completely misunderstand the psychology of a traffic stop. When an officer leans in and claims they smell alcohol, you need to understand that this is rarely a genuine observation. It is a calculated, rehearsed fishing expedition. Think about the pure biology of the situation. Pure alcohol, ethanol, is completely odorless. It literally has no scent. The police know this, the prosecutors know this, the judges know this. The only thing an officer might be smelling is the flavoring of a beverage, a spilled drink, mouthwash, or even a completely unrelated chemical compound. But they use the phrase, "I smell alcohol," because it is a proven psychological trigger designed to strip away your defenses. Put yourself in the officer's boots for a moment. They approach a vehicle in the dark. They have no idea if you're a choir teacher coming from late practice or someone who just chugged half a bottle of whiskey. They need evidence, and they need it fast. So they throw out an accusation disguised as an observation. And this is exactly where the trap snaps shut. Human beings have a deeply ingrained psychological need to justify themselves to authority figures. The moment you're accused, your brain screams at you to explain, to rationalize, to prove your innocence. You think you can talk your way out of it. You say, "Officer, I swear I only had one glass of wine 3 hours ago with a massive steak dinner." You smile. You hand over your license. You think you're being a cooperative, upstanding citizen. But here is the terrifying reality. You just handed them a conviction on a silver platter. Every single syllable you just spoke was not a defense. It was a legally binding admission of guilt. By admitting you consumed any amount of alcohol, you just gave that officer the exact probable cause they need to drag you out of the car. When you mention the time frame, you are giving the prosecutor the exact mathematical formula they need to calculate your alleged blood alcohol content for a jury. You think you are explaining your innocence, but in the eyes of the law, you are signing your own arrest warrant. The officer does not care about your steak dinner. They do not care that it was only one glass. They only care that you just confessed to drinking before driving. But the real nightmare hasn't even started yet. You might think, okay, I just won't say anything. I will just roll down my window, hand over my license, and stare straight ahead in complete silence. If you do that, you are walking into the second deadliest trap of the night. Police officers are trained to weaponize your silence against you if you do not invoke your rights properly. If you just sit there refusing to speak, the officer is going to walk back to their cruiser and write down 3 devastating words in their official report: combative, evasive, and uncooperative. And when your case goes to trial, the prosecutor will stand in front of a jury and argue that your bizarre silence was a clear indicator of a heavy intoxication. Juries are inherently biased. They want to trust the person in the uniform. If the police report paints you as an aggressive, silent jerk who refused to engage, the jury will convict you based on character alone, regardless of the actual evidence. So you cannot over-explain. You cannot confess to having just one drink. You cannot just sit there in awkward silence. What on earth are you supposed to do to survive this? The secret lies in a profound legal distinction that the justice system desperately hopes you never figure out. It is not illegal to consume alcohol and then drive a car. It is only illegal to drive a car while your mental or physical faculties are impaired by alcohol. That is a massive difference. Courts across the entire nation have repeatedly ruled that the mere odor of an alcoholic beverage is not enough to prove impairment. Cases in states from New York to California have established precedent that a smell alone cannot justify a conviction. It is merely a stepping stone. The officers claim that they smell something is legally worthless on its own. It only gains power if you open your mouth and provide the supporting evidence they desperately need. That is why you must take absolute control of the interaction the moment the accusation is made. You must short-circuit their interrogation training with language they cannot manipulate. Memorize this exact script. Burn it into your brain. When the officer says they smell alcohol or asks how much you have had to drink tonight, you look them in the eye and say, Officer, I am respectfully invoking my Fifth Amendment right to remain silent, and I decline to answer any questions about my day, my travels, or my consumption. Am I legally free to continue my journey, or am I being detained? Let me break down exactly why these words make you legally bulletproof. First, you are explicitly stating that you are invoking a constitutional right. This is entirely different from just giving them the silent treatment. By verbally invoking your Fifth Amendment right, you are placing a legal shield around yourself that a prosecutor cannot use against you in court. The Supreme Court has ruled that the invocation of your constitutional rights cannot be presented to a jury as evidence of guilt. Second, you are being completely polite. By using the word respectfully, you are destroying their ability to write that you were combative or aggressive in their report. If they are wearing a body camera, the footage will show a calm, collected citizen exercising their rights, not a slurring, aggressive drunk. Third, and most importantly, you're asking if you are free to leave or being detained. This is a masterstroke of legal strategy. This completely traps the officer. You're forcing them to make a definitive legal choice on the spot. They can no longer play the casual conversation game. They either have to let you drive away, or they have to officially detain you. And if they choose to detain you, they must have articulable, reasonable suspicion, which, as we just established, is incredibly hard to prove with just an alleged smell and absolutely zero admissions from you. But you must be prepared for the pushback, because no cop is going to just give up that easily. They will try to shame you. They will lean in closer and say, "Listen, if you have nothing to hide, just talk to me. We can clear this up right now. Do not fall for the false empathy." It is a textbook interrogation tactic. When they do this, you deliver your backup script. "Officer, I have provided my license, registration, and insurance as required by law. I will not answer any investigatory questions without my attorney present." Now, this is where the situation usually reaches its breaking point. The officer realizes they cannot outsmart you verbally, so they shift to physical intimidation. They will order you to step out of the vehicle to perform standardized field sobriety tests. Following a major Supreme Court ruling, an officer does have the authority to order you out of your car for officer safety. You must comply with the physical order to exit the vehicle. Do not resist, do not argue, step out of the car. But here is the critical secret that thousands of people go to jail for not knowing. Stepping out of the car is mandatory, but participating in field sobriety tests is entirely voluntary. You're never legally required to perform the eye tracking test, the walk and turn, or the one-leg stand. And you should absolutely never agree to do them. Let me explain why these tests are nothing more than rigged carnival games, designed to manufacture probable cause. You could be entirely sober, functioning at 100% capacity, and still wildly fail these physical coordination tests. Think about the reality of the situation. You're standing on the side of a highway in the dark. Cars are blowing past you at 70 miles per hour. The wind is hitting you. Flashing strobe lights are blinding your peripheral vision. Adrenaline is dumping into your bloodstream because an armed government agent is scrutinizing your every twitch. Now, under those terrifying conditions, they expect you to walk a perfectly straight, invisible line heel to toe, pivot flawlessly, and count out loud without missing a beat. If you start the test half a second before they tell you to, that is marked as a clue of intoxication. If you use your arms slightly for balance, that is a clue. If your foot drifts an inch off the imaginary line, you fail. It is a completely subjective test, graded by the very person who is actively trying to arrest you. Medical conditions, fatigue, anxiety, and even minor inner ear issues can cause a sober person's eyes to jerk during the penlight test. These tests are not objective science. They are entirely designed to create a documented trail of physical failures to justify putting you in handcuffs. So when they ask you to follow their pen with your eyes or stand on one leg, you give them this final, unwavering response. "Officer, my attorney has instructed me to never participate in voluntary roadside physical agility tests. I respectfully decline." Notice the framing. You're not arguing with the science of the test. You are deferring to legal counsel. This removes the personal confrontation while maintaining an absolute refusal. If the officer is hell-bent on arresting you, they might still put you in handcuffs based on whatever fragile evidence they think they have. But listen to me. An arrest is not a conviction. By maintaining your silence, refusing to admit to a single drop of alcohol, and declining their rigged physical tests, you have given them absolutely zero hard evidence. When your attorney gets the police report and the body camera footage, they are going to laugh the prosecutor out of the courtroom. The case will crumble because you denied them the one thing they needed to win, your cooperation in your own demise. Understanding this psychological battlefield and knowing your exact rights before you ever see those flashing lights is the literal difference between going home to your family and having your life completely derailed by the criminal justice system. But this is just one piece of the puzzle. What if the officer decides to bypass the alcohol question entirely and tries to illegally search your trunk based on a totally different excuse? You need to know exactly how to shut that down before they start tearing your car apart. Check out this next video where I reveal the absolute worst mistake drivers make during a vehicle search request and the exact phrase that stops an illegal search dead in its tracks. I will see you over there.